Hi, my name is Robert Chelle with Chelle Law, and my law firm assists physician assistants with employment contract issues. Today, I'm going to talk about whether a 2-year non-compete is reasonable for a physician assistant. So, if you're a PA and you're about to sign either an employment agreement or many independent contractor agreements, it's going to include what's called restrictive covenants. And a restrictive covenant essentially prohibits the PA from doing something either during or after the contract terminates. Normal restrictive covenants would include a non-disparagement clause, a non-solicitation clause, and then a non-compete, which is what we're going to talk about today. So a non-compete prohibits the PA from working either within their specialty or as a PA, completely within a specific geographic radius for a specific amount of time. So let's kind of take each of those components and then we'll get into a discussion about how long a non-compete should be. So a couple things you need to look for when it specifies exactly what the PA is prohibited from doing. Either it'll say you cannot practice as a physician assistant at all, or let's say you're working for an orthopedic practice, it may say you can't work in orthopedics as a physician assistant. The reason why this is important is if you're absolutely tied to an area and there's absolutely no way that you can move after the contract terminates, then at least you'll have other opportunities as a PA. Even though you may want to stay in your specialty, at least you would have another opportunity until the non-compete would then end, and then you can kind of get back into, in this case, orthopedics if you wanted to. So you need to make certain there's language that is limited to what you are doing for that specific employer. Next, the geographic radius, usually somewhere between 5 to 15 miles would be considered reasonable by a court. There are some states, a handful of them in the United States, where non-competes are completely unenforceable. But for those where it is enforced, the courts will look to kind of the reasonableness of the non-compete. And then kind of the factors that go into that are what kind of community is it? So, 10 miles in New York City could be vastly different than 10 miles in rural North Dakota, where you may have zero other opportunities if you're not working for a practice. So you need to think about, all right, what is the setting where I am? And, 10 miles one place could be vastly different than 10 miles in another. Now, as far as how long it should last, most non-competes last somewhere between 1 to 2 years. I would say almost no non-compete for a provider over 2 years would be considered reasonable or enforceable. So if you're a PA and you have a non-compete, you want to get it as close to 1 year as possible. Most states do not have statutes or laws that specifically address non-competes. There are a handful, but most of them base kind of what is considered reasonable on past case law. And most courts that then will litigate these non-compete cases will kind of give their opinion on what they would consider a reasonable amount of time. And most judges find that 1 year or no more than 1 year would be considered a reasonable amount of time. It's pretty rare that you're going to find a non-compete that's less than 1 year. I mean, there are a handful I've seen that are 6 months, 9 months, 12 months is the standard. So what you want to do is if it's 24 months, try to eke that back down to 12 months. That would be a reasonable amount of time for a physician assistant. Now, as far as negotiating a non-compete, obviously you want to do it in advance of signing the contract, and then you need to take into account how important is it to you. So let's say you're from a community, you have family in the community, you have kids that go to school in the community, there's just no chance that you can move after the contract ends. The non-compete could be the absolute most important thing in a contract to determine whether you want to move forward with it or not. Some people move into a community just for a job, there's no kind of commitment to a community. They do not care if they have to move. In that scenario, it's probably not worth putting any time into negotiating the non-compete. But it can be a deal breaker for some. If you work for a corporate-owned practice or a hospital or healthcare network, many times they'll give a take it or leave it kind of non-compete, and it's many times better just to leave it if it's not going to work for you. You'll have a better chance of negotiating a favorable non-compete if it's with a smaller physician-owned practice. They're usually more flexible. They can't use this policy excuse. I mean, it's anyone who says that, okay, great, it's policy. It doesn't mean you can't do it. It means you don't want to. So anyway, so that is kind of what a reasonable length of time for non-compete is for a physician assistant. If you have any questions about your employment agreement or independent contractor agreement, feel free to call my law firm at the phone number listed below in the description, or you can reach us through our website, chellelaw.com. If you thought this video was helpful, please like, subscribe to the channel. We release videos every single day. All right, appreciate you watching the video. Thanks.